Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss Bharatiya Nyaya Sanhita 2023 section 93 to 99.
हेलो एंड वेलकम टू गंगा एजुकेशन। आज हम डिस्कस करने जा रहे हैं सेक्शन 93 of the भारतीय न्याय संहिता 2023. Now, this section deals with a very serious offense, the exposure and abandonment of a child. For anyone preparing for the Judiciary and APU exams, this section is an absolute must-know. So let's dive right in.
To get us started, I want you to think about this question. What's the real legal difference between just leaving a child somewhere, maybe even with good intentions, and actually committing the crime of abandonment? It's a fine line, and Section 93 is what helps us draw it.
You see, our legal system is built on a very fundamental idea. Parents and guardians have a profound duty, both moral and legal, to care for their children. A child under 12 is completely helpless, right? They can't protect themselves. Section 93 is designed to address the mischief, so to speak, that happens when this sacred duty is broken. So Section 93 is laser-focused on one key thing, the intention to permanently get rid of a child. It's not just about the physical act of leaving them behind. It's about that mental decision to completely cut ties and walk away from your responsibility. And that's why it's so serious. If the child dies because of this act, the charges can be escalated all the way up to murder or culpable homicide. Okay, so now let's get into the legal nitty-gritty. We're going to look at the exact words used in the bare act, and then we'll break it down into the essential ingredients. This is exactly the kind of analysis you need to master for your exams. So here's what the law actually says. Now, what does all that legal language really mean? Simple language में समझे तो इसका मतलब है कि if a father, a mother, or anyone who's supposed to be taking care of a child under 12 just leaves or exposes that child somewhere with the clear intent of never coming back for them, well, they've just committed a crime. Now, for the prosecution to prove this crime in court, they have to tick 4 essential boxes. First up, the accused has to be the parent or a guardian. Second, the child has to be under the age of 12. Third, the physical act of leaving or exposing the child must have happened. And finally, the fourth and most important one, the prosecution must prove the intention to completely abandon the child. This flowchart here is really useful because it shows you the logical path a court takes. It's a step-by-step process. First, they establish who the accused is in relation to the child. Then they look at the physical act itself. And only after that do they dig into the mental element, the intention. If all those pieces fit, then and only then do they consider the punishment. Okay, theory is great, but let's see how this law actually works in practice. We'll look at a practical example you might see on an exam, and then we'll discuss a landmark case that really defined how this section is understood. So, let's imagine a scenario. A father takes his 6-year-old son to a chaotic, busy bus station. He tells him to wait, and then he just walks away, with absolutely no plan of ever coming back. This is a textbook example of an offense under Section 93. The act of leaving him in a dangerous place, combined with that intention to permanently leave, seals the deal. This idea leads us perfectly into a foundational case, Queen Empress versus Ram Dass. And even though it's from 1885, the court's reasoning, captured in this quote, is as powerful as ever. The court recognized that a child's helplessness and the danger of the location they're left in can be powerful proof of the parent's guilty mind. So, in this case, a father literally left his young child in a deserted place, basically to get out of the responsibility of raising him. The court didn't hesitate. They found him guilty. Their logic was crystal clear. You don't leave a helpless child in a dangerous, isolated spot unless you intend to be rid of them for good. And this case beautifully illustrates one of the most fundamental principles in all of criminal law, captured by this Latin maxim, actus non facit reum nisi mens sit rea. I know, it's a mouthful, but all it means is an act doesn't make you guilty unless your mind is also guilty. For Section 93, this is everything. It means the mens rea, that guilty intention to abandon, is what turns a simple act into a serious crime. All right, let's switch gears a bit. For all of you studying for your exams, this next part is for you. We're going to zero in on the key takeaways, the punishment, how this law compares to the old one, and some quick revision tips. First thing to note, this provision isn't brand new.
It used to be Section 317 of the good old Indian Penal Code of 1860. Now, under the new framework, it's been renumbered to Section 93 of the Bharatiya Nyaya Sanhita 2023. Make a mental note of that change. So, what's the punishment? Under Section 93, the offender can face imprisonment for up to 7 years, or a fine, or both. And pay close attention to the explanation. If the abandoned child tragically dies, this section doesn't shield the offender. They can still be put on trial for the much graver offenses of murder or culpable homicide.
Okay, exam strategy time. For your prelims, you can bet you'll see direct questions. They'll ask for the section number, that's 93, the age limit, under 12, and the maximum punishment, that's 7 years. For the mains, however, it's a different game. Expect problem-based questions where your main job will be to analyze the facts and argue whether that crucial intention to abandon was present.
All right, before we sign off, let's do a super quick revision. If you take away anything from today, let it be these key points. We're talking Section 93 of the BNS. The core idea? Punishing the intentional abandonment of a child under 12. The punishment? It can go up to 7 years. And the number one key ingredient? Mens rea, that guilty intention to wholly abandon the child. And that brings us to the end of our detailed breakdown of Section 93. It's a truly vital law that protects the most vulnerable among us. For more legal deep dives like this, all focused on your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Thank you for watching. Hello, everyone, and welcome to Ganga Education. Today, we're diving into a really crucial piece of the new Bharatiya Nyaya Sanhita 2023, and that's Section 95. Now, this section tackles a very sensitive and important issue: the crime of hiring a child to commit an offense. For anyone preparing for the Judiciary and APO exams, believe me, a solid understanding of this provision is absolutely non-negotiable. So, let's break it down together. So, here's how we're going to approach this. First, we'll cover the absolute basics of the section. Then, we're going to deconstruct the offense itself, to really understand its core elements. After that, we'll see how it works in the real world with examples and case law. And to finish up, we'll do a focused, exam-oriented analysis. Sound good? Let's get started. All right, let's begin with our first section, the basics of Section 95. The goal here is to get a really clear grip on the fundamental principles and the actual legal text of this provision. Okay, so our entire focus today is Section 95 of the Bharatiya Nyaya Sanhita 2023. At its very heart, this law is specifically designed to punish those individuals who exploit the vulnerability of children by, using them as tools to carry out a crime. So, what does the law actually say? In simple language, it means that if any person hires, employs, or engages a child in any way to commit an offense, they will be punished. And here's the most crucial part. If that child actually goes ahead and commits the crime, the adult will be punished as if they had committed the offense themselves. You see, the law puts the full weight of responsibility squarely on the adult. Okay, let's move on and build on that. It's time to deconstruct the offense. For your mains exam answer writing, getting a handle on its essential ingredients and keywords is absolutely critical. You'll see that this section really hangs on 3 important keywords. First up, hiring, employing, or engaging. Now, this isn't just about a formal job contract. It includes offering money or other benefits. It includes using threats or even just persuasion. It's a very broad term. Second is child, which simply means a person who is legally defined as a child. And third, and this is so important, for the purpose of committing an offense. This means the adult's criminal intent has to be crystal clear. The whole point of the engagement must be for the child to perform a criminal act. So, this is a really crucial point. To prove this offense in court, the prosecution generally has to tick these boxes, these essential ingredients. They must prove that 1, the accused hired or engaged someone, 2, that person was a child, and 3, the entire purpose of that engagement was to commit an offense. That 4th step, where the crime is actually committed, that acts as what we call an aggravating factor, which seriously increases the punishment. So far, we've really been talking about the theory, right? Let's now shift to the practical side of Section 95 and see how it actually works in the real world. We'll look at some examples and some important judgments. Let's think about a hypothetical situation for a moment. Imagine a gang leader who hires a 10-year-old child to go and steal mobile phones from a busy, crowded market. This scenario? It's a textbook example of a direct and clear violation of Section 95.
The child is being explicitly hired for the purpose of committing an offense.
Now, what's really interesting here is the landmark case of State of Maharashtra versus Mohad Yaqub. In this case, the accused had gotten minors involved in illegal smuggling. The court's ruling was powerful. It held that children simply cannot be used as instruments of crime, and the person who employs them is fully 100% responsible for that criminal act. You know, this entire principle can be understood through a fantastic legal maxim, qui facit per alium facit per se. In simple English, this just means he who acts through another does the act himself. And that right there brilliantly captures the very soul of Section 95. The law literally treats the adult as if they were the one who committed the crime. Now let's get to the final and, from an examination perspective, the most important section, the exam-oriented analysis. Here we're going to laser focus on punishment, legal comparisons, and the key points you need for revision. Just briefly, you might be wondering how this compares to the old law. Well, while the previous Indian Penal Code had provisions dealing with abetment, the new Section 95 under the Bharatiya Nyaya Sanhita 2023 gives us a much clearer and more specific framework to fight the exploitation of children in criminal activities. It's more direct.
Okay, let's talk about punishment. You need to pay close attention here, because this section lays out a two-tiered punishment structure. First, just the act of hiring a child for an offense carries a sentence of imprisonment from 3 to 10 years, plus a fine. But second, if the child actually commits the offense, the person who hired them will also receive the punishment for that main offense, exactly as if they committed it themselves. Now, for some very specific exam tips for all you Judiciary and APO aspirants. In the prelims, you can definitely expect a direct question on Section 95. They might ask for the section number or the specific punishment terms. For the mains exam, I'd say you should anticipate a problem-based question, something very similar to the market example we just discussed. Or you could also see a short note on the criminal liability of a person who engages a child to commit an offense.
All right, for a quick final revision, let's just lock in these key points. 1, we're talking about Section 95 of BNS 2023. 2, its core concept is punishing the act of hiring a child for an offense. 3, the punishment is 3 to 10 years plus a fine, with that extra punishment if the main offense is actually committed. And 4, remember, its exam importance is very, very high for both prelims and mains.
At the end of the day, Section 95 really shows our legal system's strong commitment to protecting children from being exploited. It sends a very clear message. Anyone who uses a child as an instrument of crime will face severe consequences. For more exam-focused legal content like this from Ganga Education, please be sure to subscribe. Thank you so much for joining me today.
Welcome to Ganga Education. Today, we're going to be discussing Section 97 of the Bharatiya Nyaya Sanhita 2023. Now, for anyone preparing for Judiciary and APO exams, this section is a really significant topic. Why? Because it deals with a very specific and very serious crime committed against children.
So let's start with the situation, shall we? Think about it. If someone steals a gold chain from a child's neck, why is that considered a more serious offense than just simple theft? The law actually sees this quite differently, and the answer to that question is found right here in Section 97.
And here it is, Section 97. Its official title is Kidnapping or Abducting a Child Under 10 with Intent to Steal from Its Person. You know, understanding its core concept is absolutely key. This section was created because the crime here isn't just against property, it's against a vulnerable child. The law gives special protection to children in this scenario. Now let's look at the wording directly from the BEAR Act. In simple language, what this really means is any person who kidnaps or abducts a child under the age of 10 and their intention is to dishonestly take some movable property, like jewelry or money, from that child, well, they will be held liable under this section.
For your judiciary exams, the best way to understand and write answers for any section is to break it down into its essential ingredients. It just makes things so much easier. So let's take a look at what the prosecution needs to prove to secure a conviction under Section 97.
So, this section has 4 essential ingredients. First, the act of kidnapping or abduction must have occurred. Second, the victim must be under 10 years of age. Third, the accused must have had a dishonest intention to take the property. And fourth, that movable property must be taken from the child's person, that is, from their body or their immediate possession.
Let's look at that first ingredient in a bit more detail. Kidnapping means taking a minor away from the custody of their lawful guardian without their consent. Abduction, on the other hand, is when any person is compelled by force or deceit to go from one place to another. For this section, either one of these acts is sufficient. Now, the most critical element of this section is dishonest intention. This is the mental element of the offender, what we call mens rea in legal terms. It's crucial to prove that the intention was specifically to dishonestly take movable property, causing wrongful loss to the child or guardian. If there was no intention to steal, Section 97 wouldn't be attracted.
And this illustrates the legal structure perfectly. You see, to prove any criminal offense, the court looks for these two things. First is the actus reus, the physical act of the crime, which here is the kidnapping or abduction. And second is the mens rea, the guilty mind, which here is the intention to steal. Only when both of these are proven does the accused face punishment.
All right, let's take all this theory and apply it to a practical example. Analyzing real-life scenarios is so important for your problem-based exam questions. So let's consider a situation.
Let's say a person lures a 7-year-old child away from a playground. Then they remove a gold chain the child is wearing. Now, here's the crucial part. Even if that person safely returns the child later, the offense under Section 97 is already complete. Taking the child away from their lawful guardian is kidnapping. The child is under 10, and the intention to steal the chain is clear. It's a textbook case.
Okay, let's talk about judicial rulings. Case laws are so helpful because they show us how courts practically interpret and apply these legal provisions in the real world.
In this context, Ramesh versus State of Rajasthan is a landmark judgment. The issue in this case was whether kidnapping a child to steal their ornaments constitutes an offense under this section. The court held the accused guilty. The reasoning was that the accused intentionally removed the child from a safe place just so they could steal the jewelry, which fulfilled all the ingredients of the section.
We can also understand the judgment in the Ramesh case through a legal maxim, mens rea, meaning guilty intention. The entire decision of the court hinged on the fact that the prosecution successfully proved the accused's mens rea, that dishonest intention to steal. Remember, the actus reus must be accompanied by the mens rea.
So now that we understand the offense, let's see what punishment the BNS provides for this serious crime. What are the consequences?
Under Section 97, a person found guilty can be sentenced to imprisonment for a term which may extend to 7 years. This can be either description, meaning simple or rigorous imprisonment, depending on the court's discretion.
And in addition to imprisonment, the convicted person will also be liable to pay a fine. The bare act says, and shall also be liable to fine, which means the fine is mandatory, not optional.
All right, let's get to some important exam tips. For your judiciary prelims, you might get a direct question from this section, like the section number or the age limit of the child. For the mains exam, you can expect a problem-based question where you'll have to identify the offense and list its essential ingredients. And always remember the dual nature of this offense. It's an offense against the person and an offense against property.
Okay, let's do a quick revision of the most important points from this section, just to make sure they stick in your memory for the exam. So always remember these three things. First, the section number 97 of the BNS 2023. Second, its core concept, kidnapping or abducting a child under 10 with the intent to steal. And third, the punishment, up to 7 years of imprisonment plus a mandatory fine. For more judiciary, APO, and law exam-focused legal content, stay connected with us here at Ganga Education.
Child trafficking is a very, very serious problem. So, what provisions does our law have to deal with it? Today, we're going to discuss Section 99 of the Bharatiya Nyaya Sanhita 2023, which deals with a very important aspect of this crime.
You see, this section addresses a really crucial aspect of child trafficking. Where does the demand come from? It focuses on those people who actually buy children for exploitation. And yes, if you're preparing for your judiciary exams, you absolutely need to pay close attention to this section.
The language of the law can sometimes be a bit complex, right? So let's break this down into simple words. Basically, it means that if any person buys, hires, or even just takes possession of a child for a heinous act like prostitution, they are committing a very grave offense under this section.
Now, the question rises, what exactly does the prosecution need to prove in court to secure a conviction for this crime? Let's understand its essential ingredients, one by one.
As you can see on the slide, this offense has 4 main elements. First is the act, that is, the act of buying, hiring, or taking possession. Second is the victim, in this case, a minor child. Third, and this is the most important, is the intention, or mens rea, the guilty mind of the criminal. And fourth is the unlawful purpose, like prostitution.
This slide explains a fundamental principle of criminal law beautifully. To prove any crime in court, two things are essential. Actus reus, that's the wrongful act, and mens rea, the wrongful intention to do that act. Only when both actus reus and mens rea come together is the crime considered complete.
To understand the theory even better, let's look at a practical example. Let's imagine a situation.
In this scenario, the brothel owner buying the child is the actus reus, and her intention to force the child into prostitution is the mens rea. Because both elements are present here, she will be held guilty under Section 99.
The judiciary plays a huge role in shaping our laws. In this context, the case of Vishaljeet versus Union of India is a landmark judgment. In this case, the Supreme Court clearly stated that child trafficking is a violation of the fundamental rights of children and that strict action must be taken against it.
An important legal maxim connected to this concept is presumptio juris, which means legal presumption. Explanation 1 of Section 99 is based on this very principle.
So what this means is that if a brothel owner keeps a minor girl, the law will presume that she has been kept for the purpose of prostitution. Now, the responsibility to prove otherwise lies with the accused. This is called a rebuttable presumption of law.
For such a serious crime, the punishment must also be severe. So let's see what punishment is prescribed for this offense in the Bharatiya Nyaya Sanhita.
As you can see, the punishment is quite harsh. The convicted person can be imprisoned for a minimum of 7 years and a maximum of 14 years. In addition to this, a fine can also be imposed.
Now that we've understood this section in detail, let's quickly go over the most important aspects from an exam point of view.
In the prelims exam, you might be asked directly about the section number or the punishment. For the mains exam, you could be given a hypothetical problem based on its ingredients, or you might be asked to write a short note on the legal presumption. So, to wrap up, for a quick revision, definitely remember these 3 things. Section 99, its core concept, punishing the act of buying children for immoral purposes, and its most special feature, the legal presumption against brothel keepers.
This section is a powerful weapon for the protection of children. But as the question on the slide asks, how can the legal presumption help protect children more effectively? Do share your thoughts on this in the comments section. For more such informative legal content, stay connected with Ganga Education. Thank you.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.